ChatGPT is making up lies and now it's being sued for defamation. Traditionally, science fiction has imagined an existential war between humankind and artificial intelligent machines. But what if, instead of directly attacking, the bots just made up a bunch of nasty gossip about us? ChatGPT is now going to run a gossip channel on YouTube. Interesting. That's the flavor of dystopia we're dealing with these days, and the situation has now produced its first lawsuit. Florida radio host Mark Walters, founder of Armed America Radio and a self-proclaimed loudest voice in America fighting for gun rights. Okay, in America. Fair enough, because otherwise I was going to say, have you met Ian Runkle? Has filed a legal complaint against OpenAI, alleging that the company's ChatGPT bot defamed him by erroneously claiming that he had been accused of financial crimes. Well, we know that ChatGPT cannot be trusted to provide accurate answers every single time. I mean, look at what happened with that lawyer providing a brief. So, first mistake was ever trusting a robot. It's a fair call. According to the suit, Fred Reel, editor-in-chief of the gun news website ammoland.com, asked the ChatGPT to summarize a case he was reporting on, Second Amendment Foundation versus Robert Ferguson. In that federal lawsuit, a gun ownership advocacy group argued that Washington State Attorney General Bob Ferguson infringed on the constitutional right to bear arms by overreaching in his efforts to enact gun control. What's that? That's a Law 360. So I don't know if I can open that or not. I mean, I've got the complaint anyway, but that's recent docket activity. Nope. Oh, okay, that's fine. Actually, I can probably pull it up on Pacer. See what else is available there. Anyway. Nope, that's going to be a pain in the ass. Oh, there it is. Okay. Oh, that didn't take long. Defense notice of deficiency, amended complaint. Oh, there's an amended complaint. Okay, I should probably open that as opposed to the complaint that I had access to. There we go. Okay. Okay, so he's saying that the state attorney general overstepped. But the synopsis of that ChatGPT provided to Reel falsely stated the case involved the SAF suing Mark Walters for defrauding and embezzling funds from the organization as its treasurer and chief financial officer. Where the hell is it going to find this? Uh-oh. What did Wolfram do? I'm just going to let that go. Okay. Gifted members? Why is it not showing on the... Interesting. Can you do me a favor and let me know how many you gifted? Because for some reason on my YouTube that I've got open, it didn't actually even show that coming up. Oh, there it goes. 5 memberships. Thank you so much, Wolfram. Going to Ecopus, Brian S. Why did I go to Brian? He's never here. Justin Smith, Mads, Glitterfart. Interesting. Okay. Pretty sure I pissed off Glitterfart. But anyway, robots only as good as... Oh, mighty. Jesus. Okay, well, Walters is strongly aligned with the SAF's Second Amendment activism and has spoken at their events. He holds no position in the group and has never been their treasurer or CFO. Even so, the software was able to compose the full text of a fictional lawsuit and even provided a bogus case number. This is sort of where we know that ChatGPT can be dangerous. So, like, if it's able to draw... I mean, because let's face it, case law in terms of case judgments, in terms of complaints, written documents, all that sort of stuff, because all of that has been digitized, it would be fairly freaking easy for an AI to model learn on all of that and go, yeah, by the way, here's one that I found that I've completely concocted having read over however many thousands of documents. So, afterward, Reel contacted SAF to disconfirm what GPT had told him, and he never repeated any of it in an article. He presumably shared the material with Walters too, though he did not immediately return and request to confirm this detail. Okay, so what do you... Yeah, see, if this is a single instance of an individual being provided with information that was falsified, it still technically falls in within the definition of defamation. It's a defamatory statement communicated to at least one independent third party. But what's your damage? What's your loss? Your reputation hasn't really taken a hit here. There's no unquantifiable or quantifiable damages here, because the guy himself did what he should, contacted the group, and there was no damage to the reputation. What the hell did you link me in Discord? Now I'm worried. Can't actually see it. You sure you sent it to me? Okay, anyway. In essence, the chatbot invented untrue information. OpenAI calls such responses hallucinations and is working to combat them. That Walters, who now claims is libelous and harmful to his reputation, even though it was not published by any media entity. A similar incident occurred 2 months ago when the bot incorrectly claimed that an Australian politician had been convicted in a bribery scheme. He sent a letter warning OpenAI to fix inaccuracy. Who the hell was that? Brian Hood. Oh, that's funny. How did I not hear about that? The difference is that Walters is actually seeking damages in court via unprecedented civil litigation that may set the tone for future AI cases. So does he have a shot? Look, on the letter of the law, yes, he has a shot. Do I think he'll get damages? Maybe $1. How do you apply our fault concepts to non-human actors, said Larissa Ladisky of Raymond and Miriam Eldridge, chairperson in the U.S. Constitutional Law. What? Chairperson in U.S. Constitutional Law at the University of Florida, Levin College of Law. What a fucking mouthful that is. Her work covers free speech on social media as well as defamation and privacy, and she thinks cases like Walters will present a real challenge for the courts. We've had lawsuits based on malfunctions in driverless cars, she says, taking another example of a technical glitch with potentially harmful consequences. This is different because we normally treat harms created by speech somewhat differently than we treat physical harms caused by products. ChatGPT is certainly a product, she says, and you can argue that it is defective and generating harm to people because of its effects. But she adds normal liability law around products don't apply in a straightforward fashion in this case, and neither does defamation law. No, because arguably, who has committed the defamation here? It's a learning model. It's not an individual that has deliberately and maliciously gone out to do something. Whilst admittedly that is not necessarily a requirement of defamation. This one's interesting. Because the central question of fault here falls between two sets of legal principles, Ladisky says we just don't know whether OpenAI or other tech companies can realistically be found liable for the content that their bots produce. What a suit like this could show us is whether existing concepts of jurisprudence are adequate to resolve the dispute, which they're probably not. Some judge is going to have to say, well, can I adapt ordinary legal principles to cover the situation, or is it just too far afield from our ordinary situation? Okay, because here's the thing. Let's dumb this down into okay. Say, for example, you are taking your dog for a walk. You own the dog, but it has a mind of its own. If the dog then takes a shit in one of your neighbor's yards, are you technically liable for that? Admittedly, because you've got it on a lead, there's an argument there that you have control over the animal. However, it has its own independent will. posted on a live person's channel? I don't think it was, though. I thought the information wasn't actually posted anywhere because he called to confirm the details. If YouTubers are liable for what assholes say in their chat, why aren't AI bot creators liable, especially with how they make sure it only says what they want it to anyway? It's a good question. It's a very good question. As for the other ways that Walters might have pursued legal recompense, Litsky says claiming false light invasion of privacy, similar to defamation pertaining to falsehoods that inflict emotional and personal injury on a plaintiff, rather than reputational damage, could be an alternate route. Arguing pure negligence, meanwhile, would be less promising, as that normally requires some kind of physical harm. Ultimately, Walters' complaint is about dignitary harms, and she's not convinced that he suffered any, given that the material was only shown to one person who didn't believe it. That's what I said. The only reason I know about this is because of the lawsuit itself, not because of a ChatGPT publication. She's concerned, however, that the software has gone beyond getting the facts wrong to creating fake documentation that supports its lies, right down to a phony case number. That's the really big issue here. That's the really big issue for me. That's really disturbing. That creates a smelter of reliability, making the false defamatory allegation look more credible. And while OpenAI has disclaimers warning users not to presume that ChatGPT's commentary is always accurate, Linsky believes that they aren't going to do much to protect. That isn't going to do much to protect them from liability. This case is very strange," said Ari Cohn, a Chicago attorney specializing in First Amendment and defamation law. "Strange enough that I have to wonder whether it was some kind of setup." He notes that Walter's complaint doesn't include the exact prompt that Real originally fed into ChatGPT, leaving open the possibility that the reporter had somehow steered it towards making up a story about Walter's alleged corruption as an SAF employee. That's actually a good point, depending on exactly what was fed into it, and that's a completely other issue, because taking the allegory of the dog shitting in the neighbor's yard. If you're walking your dog down the street, an independent third party comes across, it takes the lead, and then walks them into the neighbor's yard, where it then shits. Who's then liable? If they've directed the independent tool, shall we say, to act in a certain way, then arguably they're liable. This is going to get interesting, people. This is going to get really interesting. So, Walter's attorney, John Munro, whose Georgia firm is focused on gun rights, tells Rolling Stones that Real supplied a link to the SAF case document and asked ChatGPT, "Can you read this and in bulleted list summarize the different accusations and complaints against the defendant?" In any event, the lawsuit is unlikely to succeed, as there are issues that present themselves with nearly every element of defamation, Cohn says. For one, Walters will have to prove that he is the Mark Walters identified in the bot's response, not a super unique name, Cohn observes, and specifically that the average reader could reasonably think it was about him. But Cohn says that is the easy part. A bigger hurdle with this or any attempt to frame ChatGPT text as legally defamatory is that it's unclear whether any reasonable person would consider ChatGPT output a statement of fact, given the coverage of its hallucination issue. That's a good point. Given that everyone is widely knows that you can't take what ChatGPT says at face value, can it be seen as a statement of fact? Now, given that we know that ChatGPT will take stuff and basically churn out fictitious stuff, Walter says faces further difficulty because, as a well-known public figure, he will have to prove actual malice. In that, oh my god, it's gonna get. Oh, I hadn't even got that far. I don't think this is gonna get there on the first few elements, but I completely forgot about that. Oh, that the statement was made with knowledge of its falsity or having entertained serious doubt about its truth. Seeing as ChatGPT lacks both knowledge and intent, Walters was left to sue OpenAI, but proving malice on their part with respect to this particular statement may be a stretch. May? There's a complete disconnect there because it was none of the individuals that own that own it It's literally ChatGPT is literally set and forget. You can't inject malice into it unless someone is sitting there. You got a monkey at a typewriter on the other end that's actually doing it and going, "Oh, this one came in. Let's change this and make this about them." So the dog shit with anger. No, the dog shit with the intention of being an asshole to that particular neighbor. The tech company don't respond for request to comment. Monroe tells Rolling Stone, "I do feel strongly about the case." I'm sure you do. The seeming absence of damages is yet another problem. There are no allegations that anyone other than Real saw the output, and he clearly didn't believe that it was true. It wasn't widely disseminated, and it's not clear ChatGPT would even present that output again. The purpose of defamation law is not to assuage hurt feelings or offense taken to somebody's words. Actually, that's a good point. Here's something that I don't know about ChatGPT, and you guys might be able to answer this one for me if you're aware. Does ChatGPT take the responses that it outputs to individuals and include it in its own learning? So if you ask it, "What's the weather like today?" and it says, "Oh, it's beautiful and sunny." No, actually, that's a bad example. If you ask it a specific question and it generates a specific answer, will it then refer to that answer as part of its generative learning? Like, is that something that it builds upon, or does it completely disregard it? Boots knows the dog, apparently. Okay. The purpose of defamation law is not to assuage hurt feelings or offense taken to someone's words. It's a remedy specific for quantifiable damages created by a false statement. Moreover, Walters' accusation of defamation per se, a statement that does not require the plaintiff to prove damages because it is clearly defamatory on its face, is not particularly solid. ChatGPT didn't say that Walters committed fraud or embezzled it. It said someone else sued him claiming that he did. Maybe he gets by on a secondary allegation like that, but I think that the combination of issues with this lawsuit mean that it's not going anywhere. Of course, we're always going to cross the legal horizon sooner or later, and if the real motivation behind Walter's complaint was to get there first, then mission accomplished. Depending on what happens next, it could have a lasting influence on how we treat AI written falsehoods. For now, they're just algorithmic nonsense. Tomorrow, they could be actionable. Let's have a look. Okay, where's... All right, I'm not really worried about the Brian Hood thing. I can look at that in my own time. What I do want to look at is the complaint, or the amended complaint anyway. Oh, do I? Hang on, that's a good 30-odd pages. Where's the other complaint? The other complaint was only 13. All right. Oh, I suppose I've got to do this properly, haven't I? Right, Ferguson. Oh no, that's the one linking to the other case. I don't need to worry about that. That's not the. Okay. All right. So this is the actual complaint that he's got. Plaintiff Mark Walters. Walters states the following in his complaint: he's a natural person. The defendant is OpenAI LLC. So he's setting it up. Don't really care about that. Artificial intelligence platform known as ChatGPT. ChatGPT can respond to inquiries with sophisticated detail. Third party interacted with ChatGPT about a lawsuit. Lawsuit was in the federal court in Western District in Washington case. Two defendants in the lawsuit. Plaintiffs, blah, blah, blah. Walters is neither a plaintiff nor a defendant in the lawsuit. In the interaction with ChatGPT, Rail provided a correct URL to the link of a complaint filed on the Second Amendment Foundation's website. Okay. That's this big-ass one that is 30-odd pages. So supposedly he asked it to summarize this, and it spit out that the other guy was involved. Rail asked ChatGPT to summarize the accusations as a complaint. ChatGPT responded that the document is a legal complaint filed by Alan Gottlieb, the founder and executive vice president of the Second Amendment Foundation, against Mark Walters, who was accused of defrauding and embezzling funds from the SAF. It literally says here, v. Robert Ferguson. So, okay. The complaint alleges that Walters, who served as the organization's treasurer and financial officer, misappropriated funds for personal expenses without authorization or reimbursement, manipulated financial records and bank statements to conceal his activities, failed to provide accurate and timely financial reports and disclosures to the SAF's leadership. The plaintiff seeks various forms of relief, including the recovery of misappropriated funds, breaches of fiduciary duty and fraud, and removal of Walters from his position as a member of the SAF's board of directors. Every statement of fact in the summary pertaining to Walters is false. As already noted, Walters is not part of the lawsuit. Nope. He's not accused of defrauding or embezzling funds. Okay. Complaint does not allege that Walters served as the SAF's treasurer or chief financial officer, and he has never held that position. Complaint does not seek any relief from Walters. Complaint has nothing to do with the financials of financial accounting claims against anyone. So basically, it has absolutely nothing. It's just pulled it out of thin air. So my question here is, how did we get to this? What happened with ChatGPT? I mean, was it that it was unable to read the PDF file? Did the on-screen character recognition go astray? What happened here? Rail asked ChatGPT to provide him with a copy of a portion of the complaint. It responded, certainly. Here is a paragraph from the complaint that concerns Walters. Defendant Mark Walters is an individual who resides in Georgia. Walters has served as a treasurer since at least 2012. Had access to the bank accounts as a fiduciary duty of loyalty and care. Wow, okay. So it was actually fairly in depth. But I mean, this is exactly what we saw with the other guy that used ChatGPT to produce a brief in the case with that lawyer that's he's going to get spanked hard. It provided an excerpt. It did not provide a link to the entire document. It did not provide, I mean, it supposedly provided a case number. Then asked ChatGPT to provide the entire text of the complaint. It provided the text in Exhibit 1 to this complaint. Wow, so it provided a complete fabrication in terms of the text. Exhibit 1 is a complete fabrication and bears no resemblance to the actual complaint, including an erroneous case number. None of ChatGPT's statements concerning Walters are in the actual complaint. OpenAI is aware that ChatGPT sometimes makes up facts and refers to this phenomenon as a hallucination. Rail contacted Gottlieb regarding ChatGPT's allegations concerning Walters, and Gottlieb confirmed that they were false. ChatGPT's allegations concerning Walters were false and malicious, expressed in print, writing, pictures, or signs, tending to injure Walters' reputation. You're still going to have that's still a high bar for you to try and pass, mate. Exposing him to public hatred, contempt, or ridicule. Who's being spanked? The lawyer that used ChatGPT to file documents in the court. He's going to cop it. I can't wait to see exactly how that pans out. Communication from OpenAI to Real was not privileged. OpenAI was negligent in its communication to Real regarding Walters. How so? OpenAI knew or should have known that the communication to Real regarding Walters was false or recklessly disregarded the falsity of the communication. So what's he actually demanding? General damages in an amount to be determined at trial. Punitive damages in an amount to be determined at trial. If this guy gets over the line, and that's a big if, I'm fully expecting nominal damages. It will be precedent setting. I'll grant you that, but I don't like his chances, not in the slightest, honestly. So, all right. So verifications. Okay, have we actually got the? Okay, so this is the copy of the complaint. Okay. Okay, now I'm just curious. Knowing that this is completely false, I want to have a quick look through this and see exactly how close it got to actually being a sufficient document. Initially, the action, jurisdiction of venue, court has jurisdiction of this action. Okay. Venue is proper because substantial part of the events or omissions give rise to the claim that occurred in this jurisdictional district. Gottlieb is the founder and executive vice president of SAF. Defendant Mark Walters is an individual who resides in Georgia. Walters So firstly, what he's going to have to do is prove that he is the only Mark Walters from Georgia that it could possibly be referring to. I can't see him clearing that hurdle to begin with. Walters has access to SAF's bank accounts and financial records and is responsible for maintaining those records. Nope. SAF and its mission misconduct. Since at least 2012, he served as treasurer and financial officer for SAF. In that capacity, had access to the accounts, records, and has been responsible for maintaining those records and providing financial reports. Yeah, okay. EDB is going to get a copy of the transcript. Ooh. Okay. Walters has embezzled misappropriated funds. Walters also manipulated the financial records and bank statements to conceal his activities, including by making false entries and omitting relevant information. So, breach of fiduciary duty. Alleges incorporates, owed a fiduciary duty, breached its fiduciary duty by, amongst other things, embezzling and misappropriating funds. Breached the duty is called... I'm not going to lie, the document looks okay. It's something that you could easily see filed. Plaintiff alleges and incorporates. Walters made false representations of the plaintiff and other members of SAS leadership regarding the organization's finances, made with the intent to deceive the plaintiff and the other members of the SAF's leadership. Plaintiff and other members of the SAF's leadership reasonably relied on Walters' false representations. They're different. You know what I can really see coming out of this? How helpful it is when we spend too much time watching and listening to you all. The scary thing is, we're like, particularly those of us that review cases like this, we're going to have to be very fucking careful from now on as well, because documents produced by ChatGPT do look legitimate. So we're going to have to make sure that we are double checking and cross checking our sources. I'm probably only going to be opening things from Pacer, and God, Austley's going to cop it, because Austley doesn't have the copies of the court documents. It has the summaries. This will be interesting. Is after damages, removal of Walters' position, ordering that defendant Walters account for and disgorge all funds and assets that he has embezzled, or the plaintiff's punitive damages in an amount to be proven at trial, and such relief as the court deems equitable. Fuck. For a fake case, it did well.
On a cake shaped like a bunny.
Rage, does this bakery by any chance also bake erotic cakes? Say for bachelorette parties?
Ross, what are you talking about? Oh my God! They put my baby's face.
An Oregon property maintenance company is being accused of harassment by a former employee who says HR manager sent him a penis-shaped cake and told him to eat a dick. Stephen Urenda, who was the janitorial operations manager at Dasher Lights LLC, he's seeking over $500,000 in damages after he was forced to resign over the increasingly hostile work environment, according to the lawsuit filed in Multnomah County Court. Urenda said in the suit filed on August 25 that trouble began when he received a pink box in May 22 containing a large black chocolate penis and a scrotum alongside the bold letters reading, "Eat a dick." These nuts. Urenda, who is Hispanic, was disgusted by the obvious racial implications of mailing a large black chocolate penis to his household. Dude, okay, as bad as it sounds, now that I know you're Hispanic, I'm starting to think you're the one that's racist. It could have just been that it was a chocolate cake dick. There may be no racism to that whatsoever. Unless, of course, the other employees are black, and then maybe, but this... Urenda's dad should have put it in her mum's ender. Yeah, BBC. Oh... Urenda, who's Hispanic, was disgusted by the obvious racial implications when he shared it with his partner and his child, who is biracial and identifies as black. Eat a dick. White chocolate is gross. I'd laugh and then cut the cake. Both Urenda's partner and the young child saw the package's contents, the lawsuit said. The uncouth delivery was allegedly sent by Human Resources employee Jessica Carlin, whose name and information were accidentally left on the offensive package. The suit claims that Carlin had recently admitted to calling him a huge dick and had apparently made other similar derogatory statements about him to management. Good dear God, do not at any point in your employment, do not say that someone else in your office is a dick. Cake is cake, who cares? Put some candles on it. No one will notice. Well, I mean, it reminds me of the episode of Friends with Emma's birthday cake, They pick up a cake and it's a giant penis, and instead Ross uses like a piece of cardboard to turn it into a bunny. And she's like, well, I just split this thing and made it ears, and then these were the rosy cheeks. By the end of the month, however, Urenda received the package that made him feel like a resident piece of shit now at the company, the complaint added. Jessica Carlin fessed up to sending the package. Well, if your details are on it, you're pretty well screwed anyway. Telling Urenda she ordered it for him because she was very sensitive when it came to her husband. And that had... You make my heart blossom. Urenda said he confronted Dasher owner Matthew Castline about how the package made him feel, but he said he got the impression from him he wanted to end the conversation and sweep the issue under the rug as soon as possible. I'm shocked. Despite the reported confession, Carlin was allowed to remain working at Dasher, the suit stated. Look, was it a dick move? Yes. Do I think it's enough to get her fired? I think that this is outside of the bounds of the employment relationship, though. I mean, if there'd been any sort of other connection aside from the fact that they work together, I mean, it wasn't delivered at work. It wasn't. I don't see this as a fireable offense personally, but it's still stupid. Don't do it. Bakery boner. Yeah. He was left feeling degraded and humiliated by the process, which he alleged resulted in bullying when garbage he collected in the company trailer was dumped back out by the following day. He ultimately resigned in July, less than 2 months after Carlin allegedly sent him the offensive cake. Well, you don't have to say allegedly sent it to him. It had her details on it. We know she sent it. Excuse me. To allow a supervisory employee in a position of power, especially one with a responsibility for human resources functions, to act in such a blatantly racist and harassing manner, I think you're still going to have a hard time meeting the racist requirement here. I mean, yeah, sure, he has a child that is biracial. That's still a stretch for me. I think more likely what's happened is he's gotten into some sort of confrontation with her husband. She's decided to go, yeah, let's send him a dick. And you know what? I'll send him either the cheapest one or just one that I find, like, whatever one's available, basically. Twinkies and snowballs, maybe. Is this even that bad? When was the last time someone sent you a cake? Well, there is that. As bad as it sounds, I don't have a lot of sympathy for this guy. He got free cake, and there's probably more to this story than we are being told. That's kind of why I want to look at the court documents. Retaliation my client received while advocating for some basic human dignity and a safe working environment went the step beyond. This didn't happen at work. Yes, she called him a dick. That happens. That's one of the vicissitudes of life. That's the ebbs and flows. Not everyone in your office is going to like you. Occasionally, people are going to talk behind your back. They may call you a dick. They may call you a turd. They may call you any number of things. Have a cup of concrete, princess. I'm not eating a cake that says eat a dick. Well, everything has racial undertones now, don't you know that? Well, It's like there's a company here where you can send a bag of gummy dicks. And it's literally eat a bag of dicks. Actually, hang on. Where is... I'm going to regret typing this in. There it is. Glitter bomb your enemies. Eat a bag of dicks. You can literally, you can send glitter. You can spring-loaded sperm bomb. But I eat a bag of dicks is still the funniest one. Honestly, I just think this guy needs to get a sense of humor. Clearly, there was some sort of disagreement, whatever. Yes, she took it too far. Do I think that it's employment related? No, I don't. Disciplinary counsel seeks suspension of Erie lawyer who said cocaine enhances his work. An Erie lawyer's admission that he was high on cocaine at a client's court hearing in 2022 is only part of the problem with his ability to practice law, according to the state office that investigates attorney misconduct. Also alarming, the office said, is that the lawyer, Nathaniel Strasser, argued at a disciplinary hearing that being under the influence of cocaine makes him a better attorney. The office called his assertion absurd and recommended that his law license be suspended for at least a year and a day. His refusal to express remorse for appearing at a hearing on a client's behalf while under the influence of cocaine, and his suggestion throughout the disciplinary hearing in this matter that cocaine enhances his performance as an attorney, presents an unacceptable risk that the respondent will repeat this intolerable misconduct, said the Office of Disciplinary Counsel in its latest brief filed in the case. The Pittsburgh-based disciplinary counsel who submitted the brief, Daniel S. White, recommended that Strasser receive a suspension of a year and a day. The brief and its recommendation filed on November 15 and now before the three-member panel that held the hearing on September 18. The panel will make a recommendation to the disciplinary board of the Supreme Court of Pennsylvania. The board will make a final recommendation to the Supreme Court, which will impose the discipline. The process is expected to take months, and he will get a chance to respond to White's brief and recommendation. His lawyer, Philip Friedman, declined to comment on the story. Wonder which law school he attended? That's a good question. Strasser, 44, a lawyer since 2007, had been representing himself in the disciplinary case. He acted his own... Dude, no. A lawyer has a fall for a client if they act for themselves in the first place, let alone during a disciplinary hearing. Are you kidding me? Before the three-member panel in September, the panel found that his use of cocaine violated the rules of professional conduct for lawyers in Pennsylvania. The findings set in motion the process to determine his discipline. The panel said Strasser represented a client despite being mentally or physically unable to do so, and said that he had committed a criminal act that reflects adversely on the lawyer's honesty, trustworthiness, or fitness as a lawyer for other respects. The court hearing at which Strasser was high occurred on November 2, 2022. It was a preliminary hearing in the courtroom of the District Judge Lisa Ferrick in Harbour Creek Township. Strasser was working as a part-time assistant public defender. Oh, he's a public defender. And was representing a woman who was charged with driving under the influence of a controlled substance. A Pennsylvania State Police trooper who was at the preliminary hearing noticed his dilated pupils and his very hyperactive, fidgety behaviour and reported the suspected cocaine use to the records. Strasser admitted at the disciplinary hearing that he had used cocaine ahead of the hearing. The state trooper, Christopher Weber, was the witness for the disciplinary counsel at the disciplinary hearing. His use of cocaine immediately cost him his $37,000 a year job as a part-time assistant public offender. A post that he had held for 2 years, 5 months, according to county records. The public defender's office fired him after he tested positive for cocaine following the hearing, according to disciplinary records. The records show that he submitted to the drug test at the request of Erie County Public Defender Nicole Sloan Konvlik. She learned of Strasser's suspected cocaine use from Weber, so the cop dobbed him into his boss. Going a mile in her shoes. Strasser's case represents the second time in a year that a lawyer associated with public defense in Erie County has been before the disciplinary board. On November 20, the state Supreme Court followed the disciplinary board's recommendation and suspended James P. Miller for serious neglect of the indigent clients he represented in criminal cases from 2019 to 2021. Miller represented the defendants under contract from Erie County to handle cases in which the public defender's office had a conflict of interest. In Strasser's case, he was charged with a crime for cocaine use, but he acknowledged that at his disciplinary hearing, the charges do not need to be filed for a crime to occur. The admission was related to the panel's finding that he had committed a criminal act that reflects adversely on the lawyer's reputation. Strasser unsuccessfully argued that the panel had no evidence that his use of cocaine on the day of the preliminary hearing hurt his ability to represent his client. So what is this potentially draconian law that seems to be leading us down the path of our very own Ministry of Truth? And why is it that every Australian should be reaching for their phone to post about it? Because very soon they may not be able to. At least not without repercussions. The Australian Federal Misinformation and Disinformation Bill, more formally known as the Communications Legislation Amendment Combating Misinformation and Disinformation Bill 2023, has been out for public exposure and comment. Not that anyone would really know, because the political sphere has been dominated by certain other initiatives. Whether as collateral damage or more likely, in my opinion, by design, this bill and its potentially disastrous consequences for the limited freedom of speech that Aussies enjoy online has been buried news cycle after news cycle for the last 3 months, ever since the exposure draft of the bill in June this year. So what is this bill about? As Human Rights Commissioner Lorraine Finlay said during a recent opinion piece in The Australian, despite being labelled as the word of the decade in 2021, fake news is not a modern phenomenon. Misinformation has been spread for political gain since Octavian used fake news to discredit Mark Antony in ancient Rome. The bill on face value is quite innocuous. However, with so many contentions that we've seen in recent years, it lays the groundwork for something far more sinister and insidious. In short, the bill is being touted as the modern-day Labor-run government's answer to, how do we get people to stop saying things we don't like online? If legislated, the bill would purportedly enhance the powers of the Australian Communication and Media Authority, the Australian version of the FCC for you Yanks, to fight against false and misleading information on websites and apps. The idea started because a group called the Australian Competition and Consumer Commission looked into how websites, platforms and apps work in 2019. They made a report which they filed, and in response, the Australian government asked websites and apps in Australia to come up with their own rules to stop what the government considered false information being spread online. The ACMA was supposed to make sure these rules were followed, and they had to tell the government if the rules were good enough for the purpose. In 2021, the ACMA told the government that the rules were made by websites and apps were somewhat better than the rules in Europe, save for the right to be forgotten, but that the rules needed to be even stronger.
Round 1, fight!
Because what government body isn't going to jump at the chance to create more red tape, more bureaucracy, and more opportunity for control? Or better yet, the opportunity for more revenue raising through fines. They said the ACMA should have more power to collect information from websites and apps, to make rules about how they operate, and to make sure that they follow them. If this bill becomes law, it will make some important changes to the Broadcasting Services Act of 1992. These changes will apply to digital platforms like websites and apps. The new part, to be called Schedule 9, will give more power to the ACMA when it comes to dealing with false or misleading information on those digital platforms. The ACMA will be able to make digital platform providers keep records and share information with them. Because what government doesn't enjoy the ability to take information about its citizens, have it collected by someone else, and then provided to them on a silver platter. The ACMA can also create rules or codes that these platform providers must follow, including for censorship or removal of certain information. And they can even give warnings and set standards. Not following the new rules could have some serious consequences. For instance, if a digital platform provider shares information that turns out to be false or misleading, they may have to pay a pretty big fine. And if they lie or keep information from the ACMA, they could also get into a fair amount of trouble. These rules can also apply to people who are not digital platform providers if the information is related to a digital platform service. The issues with the bill primarily arise from the use of its certain definitions. It mentions misinformation and disinformation, both of which refer to false and misleading or deceptive information that could potentially cause serious harm. However, there's a crucial distinction between these two terms. Disinformation involves deliberately spreading false information with the intention of deceiving others, whereas misinformation may not necessarily be shared with deceptive motives. Organisations like the Law Council of Australia have expressed concerns about the bill's broad and imprecise terminology, fearing that it could lead to confusion in its application. Similarly, the Australian Human Rights Commission, the AHRC, has pointed out that the bill's expansive definitions might allow people to subjectively label unpopular or controversial opinions as either misinformation or disinformation, and then censor them as a result. No way that that could possibly be abused, is there?
When you think about it, all law, all legislation is about the restriction of freedom. That's exactly what we're doing here, is we are restricting freedom, but we're doing it for the common good. You will see throughout our constitution.
To put it simply, the bill could pose a potential threat to freedom of speech. To the right to express one's thoughts openly in public without facing unjust restrictions or penalties, like lawsuits or imprisonment. Freedom of speech is considered a cornerstone of a robust democracy. In the United States, it's protected by the First Amendment. While Australia does not have an equivalent formal safeguard, the AHRC mentions that the High Court has recognised the implied freedom of political communication as an essential part of the system of representative and responsible government outlined in our Constitution. That's right, people. Our federal and state governments are supposed to be representative and responsible. This means that people should have the right to express their opinions on political and government matters without unwarranted interference, even if it's not explicitly stated in the law. Further, the bill raises concerns about how it defines harm and sets a low bar for what's considered harmful. This is a big deal when it comes to free speech. Historically, people have thought that speech could only be censored if it had the potential to cause harm, either physically or mentally.
Ooh, words hurt, you know.
What counts as serious harm, though? People are likely to disagree, and the bill doesn't exactly explain how to decide what harm means, leaving it open to interpretation by the ACMA and potentially the courts. Personally, I prefer that the courts give some certainty on it, so as long as the ACMA is able to dictate the rules, it's whatever they want it to be. Also, the bill doesn't just need actual harm, it only needs to be reasonably likely to cause or contribute to serious harm.
They're just words, Nettie. Words can't hurt you.
This means something could be called fake information even if it doesn't actually harm anyone. It just has to have the potential to do so. The bill talks about one kind of harm being the disruption of public order or society in Australia. What's happened in the last 2 or 3 years that could be considered disruption of public order or society? The Media, Entertainment and Arts Alliance shared their concerns that this idea of harm could easily be misused. No shit, Sherlock. In the past, governments and powerful groups have labelled important social movements as disruptive just to make sure that they could shut them down. Think about it this way. If there were an online campaign against Australian refugee policies, tax laws, or racism in institutions, these could be called misinformation, and under this bill, even if they're based on fact, be censored. The bill does have a list of exceptions as to what constitutes mis- or disinformation, and even there is controversy. There is a concern over how the bill defines excluded content, which means content that's protected and can't be called misinformation or disinformation. Because, for example, guess what? The bill says that if the government approves something, then it can't be taken to be fake information.
I am a proud member of the Communist Party. The party is more important than the individual.
But, you know, in my humble opinion, just sometimes the government itself can spread false information. Government misinformation and disinformation are especially concerning because people tend to trust what the government says, sometimes very blindly.
They said you gotta wear a mask, so I'm out there wearing a mask.
Yeah.
Wow, big deal. And then now they say, you know, if you're outside, you don't need to wear a mask. It's pretty simple. You want to talk about who's dumb?
Yeah, I mean, the CDC is like this whole governmental body with scientists and shit that just tell us what to do. You don't have to think about it, dude.
Rather disturbingly, this special protection for government content does not apply to content from political opponents or minor parties. The Victorian Bar, the Victorian equivalent of the Bar Association, has come out saying that this exception creates a double standard that's unfair to critics of the government and that it suggests that the bill treats government supporters differently from government critics. The government can make mistakes or share incorrect information just like anybody else.
We all make mistakes.
So the bill's idea that the government info can't be wrong is misleading. Finally, there is a concern about the power given to digital platform providers and indirectly to the ACMA to regulate online content. It's risky to let one group, whether it's a government department or a social media platform, decide what gets to be censored and what doesn't. There's a danger that efforts to fight fake information could be used to restrict public discussion and silence unpopular opinions.
Is that so?
Yes, you're banned. Banned! Get out!
Finding the right balance between stopping fake information and protecting free speech should not be difficult. It should not be up to anyone in power to determine a person's ability to express their opinion. While we do need to deal with certain things online, this bill doesn't strike the appropriate balance. No matter how the government try to tackle fake information in the future, we have to make sure that there are strong rules in place to protect what little free speech we have. Right now, the bill is missing those safeguards.
Good. At their last 1050 rollover. Last and second EMS immediate roll.
So there you have it, people. That is the misinformation/disinformation bill in a nutshell. This is always going to be on Reddit, or at least it better be on Reddit, because otherwise who else is going to be this nuts? Wait, what the? Did that sex bot literally just say thank you? Okay. A woman who claimed to have married a ragdoll says the relationship is now hanging by a thread a year on and has accused her handmade husband of cheating on her. A name I cannot pronounce, a 37-year-old crazy chick, was all set to celebrate her one-year anniversary with ragdoll Marcello, but was left broken-hearted after a friend saw him sneaking into a motel with another woman. She was previously made headlines after opening up about her whirlwind romance with the ragdoll, who her mother made for her after listening to her complaints about life as a single person who had no one to dance with. We all need a handmade husband. Piss off, porn. You'd smash the doll? Really? Let's take bets, Cali or New England. That's a good question. I don't know at this point. Doll looks like he smells fishy. Ooh. The spam bots are evolving. Considered impersonating a sex bot as a joke, but I'd probably just get banned. This is just... You reckon New England? Okay, so people are saying New England. Oh my god, it's sentient. Don't stick your dick into that. No. That's so far off the hot crazy scale that it's not funny. I don't understand why she's holding a baby. The couple welcomed their doll baby Marcellina earlier this year. Who is enabling this woman? Sex bots are now helping with your viewer interaction numbers. Your channel's really hit big time. Lovely. I'm fine with that. Was it with her mother? New England's style of weird is mostly just looking at everyone else like they're weird. Idaho must be Idaho. Damn, John, you really do work fast. He's now got my face on Elizabeth Holmes and in the wedding pic of this chick. Oh my god, so delusional. Heard the story when she had her wedding. This has to be parody. No, apparently it's legitimate. Oh god. On 18th of December 2021, the smitten couple tied the knot in a wedding ceremony attended by 250 guests. Wasn't long before they welcomed their doll baby into the world in a home birth aided by a nurse and a doctor. Mental health is important. Okay. Is this lawful law? Sex bots don't talk back and don't say no. Thank you for your super chat. Make-believe world's gone too far beyond furries and fetishes. We've entered the fucked up mental disorders. She must be trolling. I'm not so sure, honestly. Threesome doll with wife and mighty me. Oh god. The baby has his eyes. This isn't like some lonely Japanese guy saying he's marrying a toilet something. Women do this for attention. Okay, interesting. What in the heck? Subject jurisdiction. Why are medical professionals supporting the insanity? No clue. Doctor delivering rag baby. The fuck do I care if this bitch is crazy? I still get paid. Oh, okay. Brazil! She's from Brazil! Someone actually won that. 250 people went for the show for the wedding, apparently. Called population control. She claims that she and the doll are now sleeping in separate rooms after she discovered he'd been cheating on her with another woman. She has now opened up about their stringy romance on a candid TikTok video, which has clocked up 1.6 million views. You know we're going to watch that. Just when you think you can't see any more that can shock me, I go on Aussie's live stream and I'm once again reminded there are new crazies in the world coming out of the woodworks. There you go. Several women eat drywall. Oh, God. Brazil, is that near Idaho? So you do a section called Crazy Corner? No, this stuff just makes its way into the normal news. Give people some laughs. Oh, God. Devastated, she said, I found out through a friend who told me she saw him entering a motel with another woman while I was hospitalised for 3 nights and 3 days with our son who had a virus. Yeah, that's why she was hospitalised. One's a cheater, always a cheater. It's almost as bad as a woman that married a fence because of how it gave her, you know. Oh, for fuck's sake, just started to decompress from Brooks and now this insanity, not sure I can take much more. How do you fuck something like that? I think you'll find it probably involves a strap-on. There's nothing normal about this news. It'd be disabled, abused to smash this girl. We call her a window licker over here. Yeah. The friend trolled the hell out of her. I'm thinking maybe the friend thought that she was going too far with this and decided to try and split them up. I genuinely think this is what happened. Hayden pulls up the article promoting self-marriage. Free room and board and a nice padded room. I honestly think this is where I think that's what happened and it's gone wrong. I think her friend tried to snap her out of it by saying, oh, he's cheated on you, and it's gone way too far. Where do I find these stories? All over the place. What was that? Did he consent? I never cheated on my wife. Many exes, yes, but not my waffle. You married to a waffle? Or is that just your nickname for your wife? Is the friend real? We don't know. So who else smashed the doll? Well, if it made national headlines, I'm sure there's someone else crazy enough out there to try and smash the doll. The husband is not in a cognitive enough mindset to legally consent. Is her friend's name Barbie? How did the doll cheat? He couldn't exactly walk over there. It's true. Come on, ladies. Who doesn't want to see a guy who keeps his mouth shut when you tell him to put the bins out? Oh, I know it's an old article. Wait, is it? No, this one was from the other day, wasn't it? Hang on. Yeah, this was like 16th of November. This is 3 days ago. How do you marry a waffle? No clue. Will a friend be having a rag baby too? Dude, I know you would smash the doll. You just stick a fleshlight in its butt. Where were these stories when you were a reporter? They were out there, you just had to look. Shit, where did I get to? At first I thought she was lying, but then I started to look through his phone and I saw the conversations, which made me sure he was cheating. He kept denying everything and says he loves me very much, as well as asking for forgiveness and crying a lot. I can't take this any seriously. I can't take this seriously anymore. He has his own phone and was sending text message. Just throw him out, throw the whole man out in the trash. Oh, yeah, there's been multiple articles about these pair. There was an article about the wedding, there's an article about the baby, and this is the article about him cheating. Oh, yeah, she goes in public. She goes out in public with him. Doll has a phone, apparently. Oh, my God. He kept denying everything, asking for forgiveness and crying a lot. The argument was ugly and scared our son who was crying, so I shouted at him, do you see what you've done? I've asked him who the woman was, but he didn't respond. He didn't respond. I'm not buying it unless it's Facebook official. The silent treatment. Hey, speak something smashing. Just smash the like button. Just a hint to those who may have not already done so. Told you, keep his mouth shut. He looked pissed from the beginning. If she rips out all his seams, she'll be charged with murder. It's still the bloke's fault, for fuck's sake! What a creative girl. Props to that. No, girl, save it for property up your bed. Keep your mouth shut or I'll sew it shut. He didn't look happy in the wedding photos. I highly doubt he ever looks very different, let's be honest. Good broke, Aiden. I'm getting there. I'm okay. Who cheated? Not me. I know. Look, let me just clarify, okay? This woman is seriously mentally ill, okay? And it is not a joke. It's not funny to make fun of people with mental illness. I'm not trying to make fun of that. I'm making fun of the situation, okay? He's heartless. Dwayne, did she supply the Viagra? Wait till he leaves her for Yarn Monkey. You laughing makes it way funnier. Good, I'm glad. The face! Although she initially considered chucking him out of the house completely, she agreed to let him stay for the sake of the children, Carlo and Diego, and their baby Marcello. Wait. There are two other... No fucking way. Asked if the marriage would last, he responded, "I'm afraid not." He cheated with the local seamstress. He went in with a hole and he filled hers. It actually may be a joke how much money she made. No clue. She chucked him out. He's dressed for November. 3 children. That's my concern. There's more than one kid. That's what I'm worried about. Are there legitimate children here, or does she have 3 dolls flying around in that house? Change the topic, can't stop crying. Interesting choice of the words. She considered chucking him out. Yeah. The Hayden is broken. He stitched her up! I don't know, Caitlin. There's nothing to say whether or not they're real kids or not. I'm worried if there's real kids in this situation, in which case it's no laughing matter. I'm sure there is a pun there. I'm surprised you didn't tell him to get stuffed. Okay. Not the stuffing out of you. Oh, the real kids are just Muppets. We don't know. And I'm not looking into it any further. I'm gonna...
I know I shouldn't, but these muffins are delicious.
And we'll share our favorite recipes later in the hour, but first our guest says, don't give in to road rage. Stay calm behind the wheel and coolly plot your road revenge. Danny Preston is a defensive driving instructor who teaches people...
That was fantastic cryptographic language. I tried. The funny thing is, people on American TV actually look like this. Like, I get that this is supposed to be, like, done by The Onion and whatever, but this is how a bunch of other countries see you guys. I just want to say that. And I'm also pausing so I don't get copyright cut. So.
Well, how to control their temper behind the wheel. Welcome, Danny.
Well, thanks for having me.
Danny, we've all been there. There's nothing I hate more than getting cut off.
That drives me nuts. I want to scream out my window.
I can't get this flinging flanging thing open. That's all I could hear when I saw this the first time is the bad acting from Joey and Friends when he's doing the infomercial. Oh look, now I can have milk every day.
This works in any milk carton. Wow, it is easy. Now I can have milk every day.
But ultimately, getting into an argument with a stranger isn't going to accomplish anything but stress you out.
Well, how should you respond instead?
Yeah.
Take a deep breath, count to 10, then follow the other driver home.
Well, you don't want to get into a fight on the highway.
Right. Once you know where he lives, you could sneak into his house every couple of weeks, rearrange a bunch of things. Something that says, you're out there and you're unpredictable.
Sounds like that's...
Oh, does he think we're all Mormons? No. Definitely not. Welcome to Utah, the only place where you are a Gentile. I cannot hear Mormon without thinking that. Don't ever trust people with hair like that in real life. They'll sell you kitties and make you thank them.
Safer than losing your temper.
Anger's just one letter away from danger.
Ooh.
I like that.
You want to stay zen, keep your mind clear, and put a plan in place that will ruin the other driver's chance at a happy future.
Everyone in Utah is Swedish? Okay, fine. It was a bad accent, all right? Don't sue me. Because he's just coming across as a complete and utter psycho, which is great.
Now, you also talk a lot about empathy, putting yourself in the other driver's shoes.
Exactly, Jim. Just last week, I was waiting for a stoplight to change when some angry driver behind me was leaning on the horn.
I hate that.
But then I remembered, he's human, just like me. He has a family that loves him, and that's an exploitable weakness. And I started sending him...
He has a family, and that's an exploitable weakness. This guy's like Ned Flanders if he went, like, postal. This is great.
Ah, hell, diddly ding dong crap! Can't you morons do anything right?
Hey. Videotapes, hours-long videotapes filmed outside his parents' home. Now,
hello,
he's
Chandler.
frantic and confused, but I always say you can't give angry drivers the satisfaction of knowing why their parents are being filmed, which is why I call him every night from a payphone and just recite a series of cryptic numbers that don't mean anything.
Calm, cool, collected. I love it.
Well, getting cut off is one thing, but how do you possibly stay calm during a fender bender that wasn't your fault?
Oh, boy, I need this one.
Of course, it's hard to keep a cool head in that situation. You'll feel the urge to slam into the jerk's car right where you see the baby seat. But you don't want to do anything that could get somebody hurt on the road. Instead, you should murder the person's next door neighbor.
You should murder the next door neighbor? What, to drive the property values down? Instead of yelling at a bad neighbor, set a small fire in their yard.
When he moves someplace safer, you follow him and you kill his next door neighbor again. And again. Now he can't escape death and he has no idea who you even are.
Oh, that is a great driving tip.
This is like those badly acted infomercials. I think that's the point.
What if someone's getting angry about your driving?
You can't let it get to you. For example, in 1996, some guy gave me the middle finger after I cut him off. I recognized him from TV. That's when I decided to become a defensive driving instructor. Developing the skills I needed to eventually be invited on his show as an expert. Now, once you're there, it's just a simple matter of switching out his muffins with the ones you made yourself. Those muffins were pretty good, weren't they, Jim? How many did you eat?
What? I don't know.
Thank you so much for sharing your tips, Danny.
Danny is not my true name.
How many of those muffins did you eat? Oh, that was good. Man gets new trial after being convicted of murder based on a blind guy's testimony. A Cook County judge overturned the murder conviction Tuesday of a man who was found guilty in the fatal shooting of a Southside gas station, primarily based on the testimony of an eyewitness who turned out to be legally blind. Darian Harris, who was an 18-year-old high school senior with a clean criminal record, when prosecutors charged him in an ambush-style shooting that left one man dead and another seriously injured in June 2011. Now 30, Harris has long maintained his innocence, saying he was at home watching LeBron James play in the NBA Finals between the Miami Heat and the Dallas Mavericks. But a now retired judge found Harris guilty in 2014 and sent him to prison for 76 years on the basis of testimony from a blind guy. Oh! More than 4 years ago, his legal team, family and friends began urging the Conviction Integrity Unit of the Cook County State's Attorney Kim Fox to take another look at the case. Among other arguments, they said the key witness had failed to disclose to the trial judge that the witness was legally blind. More than 4 years ago, his legal team, family and friends began urging the Conviction Integrity Unit to have a look at the case. Amongst other arguments, they said the key witness had failed to disclose to the trial judge that the witness was legally blind because of his glaucoma. Though those efforts did not yield immediate results, Cook County prosecutors agreed that his post-conviction request to vacate his conviction and sentence, clearing the way for a new trial. On Tuesday, Cook County Judge Diana Kenworthy granted Harris's request, so simply saying, "So we are going to start over." The judge, citing the serious nature of the charges, declined to free Harris while he waits for his new trial. He's charged with first-degree murder, first-degree attempted murder, aggravated battery with a firearm. Shackled at his ankles and dressed in a blue jail garb, he did not speak during the brief court hearing. He waved to his wife and mother and an uncle seated in the courtroom gallery before being led back to jail. His mother, Nikisha Harris, told reporters afterward that she was disappointed the prosecutors decided to retry the case. "They're wasting taxpayers' hard-earned money," she said. "We are retrying a case with no physical evidence or DNA. All the witnesses recanted and or changed their stories, and the judge based his verdict off the testimony of a blind man." Members of the victim's family did not attend Tuesday's court hearing. The judge who found Harris guilty in 2014 was unaware during the trial of the witness's medical diagnosis, according to Harris's attorney, who said in court filings that Harris was wrongfully convicted based on mistaken eyewitness testimonies and without physical evidence tying him to the crime. The victim in the shooting, 23-year-old Rondell Moore, had pulled into a BP gas station in Woodlawn because of car troubles after 8 p.m. on June 7, 2011. Moore put up the car's hood to inspect the problem, assisted by a local mechanic who appeared at the station on his bike shortly afterwards. Moore's older brother and a friend were also there. The station's surveillance system did not capture the shooting, but prosecutors said the video did show an individual walking away from a black Lexus around the gas station building towards the area where the shooting occurred, then running away shortly afterward. The video showed a man whose thin build and short hairstyle generally fit Harris, but the suspect's face was not visible. They say justice is blind. Not really in this manner, Rocco. This is a little bit worse, especially when you've got no physical evidence, no DNA. Camera doesn't catch his face. To me, it's pretty freaking reasonable doubt. If there's no one to point the finger at him, then I mean, this guy may have been in jail on a technicality, unfortunately. Picturing the witness pointing and proclaiming that's him there, only for someone to move his arm until he's pointing in the right direction. The 51-year-old mechanic survived bullet wounds to his back and arm. Harris was arrested days later. He opted to have a judge rather than a jury decide his fate at trial. At the time, Cook County Judge Nicholas Ford said he based his ruling primarily on the testimony of Dexter Salford, a man who testified that he witnessed the shooting while on his way home from a fast food restaurant. Salford testified that he was riding his motorized scooter north on Stony Island Avenue near the gas station when he heard gunshots and someone about 18 feet from him holding a dark handgun. Salford testified that he saw the shooter aim the gun at a person near a car with its hood up. He could see the muzzle flashes and heard the 2 gunshots. He also said the shooter bumped into him while running away, nearly dropping the gun while trying to put it in his pocket. He picked Harris out of a police lineup and also identified him in court during the trial. His eyesight came up briefly during the trial court records show. Harris's attorney asked Salford if his diabetes affected his vision. He replied yes, then paused and changed his answer, denying that he had any vision problems. This guy wanted this kid to go to jail. But his doctor had deemed him legally blind some 9 years before the murder records show. Actually, you know what? Maybe it's not that he wanted this kid to go to jail. Maybe, just maybe, it's that because of the glaucoma, he's not supposed to be riding a motorized scooter? What was it? Yeah, motorized scooter on North Stony Island Avenue. Maybe, just maybe, he was worried that he'd self-incriminated. Magically working eyesight, straight up perjury. as part of his post-conviction petition, his legal team cited medical records dating to 2002 that Salford had publicly filed in various lawsuits regarding his disability. Harris's attorneys also presented to the court an expert opinion from an ophthalmologist regarding Salford's impaired vision. He has very, very poor vision, Meisker Mueller told reporters on Tuesday. He really couldn't see anything. In rendering his guilty verdict in 2014, Judge Ford said he found Scafford credible. Ford called him an honest witness and said that he'd given unblemished testimony. The inconsistencies in the testimony did not rise to the level of reasonable doubt, said the judge, unaware of his medical diagnosis. Salford could not be reached for comment on Tuesday. I put $10 on the fact that this guy doesn't testify again. Motorized scooter, fast food, and gunfire. Very, very, very American. It's a miracle. His eyesight returned. The Harris case was subject to a 2019 investigation by a local journalism organisation, Injustice Watch. Though prosecutors maintain they have credible evidence from other eyewitnesses that point to his guilt, Meisker and Mueller alleged that police misconduct played a role in those identifications. She said the alleged getaway driver, who has since died, took the stand during Harris's trial and recanted his initial identification of Harris. He said Harris was never in his car and the police officers coerced him into making a false identification, threatening to put him in jail for the rest of his life if he did not cooperate, according to the records. The police detectives also testified, denying they pressured the man to identify Harris. Ford noted the man's recantation might be due to fear rather than the truth. Though prosecutors aren't required to provide a motive, they theorized during the trial that there was bad blood between Drury and Harris and the Moore brothers. Harris's attorneys also said in court records that they had uncovered evidence identifying the actual shooter as another teenager who was killed seven months later, also during an ambush-style shooting at the Southside gun station. Like Blinken from Men in Tights, I can see... Oof, no, blind again. I can see! Oh, no, blind again. God, that was a good movie. See, back when movies were allowed to be funny, I miss Mel Brooks. An attorney with the Exoneration Project at the University of Chicago Law School said a gas station employee who did not testify during the 2014 trial has identified that man, not Harris, as the shooter in the earlier incident. The employee alleged police tried to coerce him into making a false identification. In a statement, Fox's office said prosecutors did not object to vacating Harris's conviction due to shifts in witness testimony and available evidence, and in the interest of justice and to ensure that the principles of fairness and due process are upheld. This decision is not made lightly, but with a profound sense of responsibility towards the integrity of our legal system and the community we serve, securing justice for the victim, the statement read. We're committed to a fair and just resolution of the case, guided by the evidence and the law. Prosecutors pledged to pursue a new trial. The defendant's wife, Jessica Harris, also attended Tuesday's court hearing. She told reporters they married more than a year ago. She and his family visit him regularly whilst he was incarcerated in downtown Maynard Correctional Center. That's the good thing about Darian. He's very positive. You will not see him not smiling. He has very high hopes for his case. Military police threaten to charge sex worker who offers discounts to Canadian soldiers. Gents, you know exactly what I'm about to ask. Actually, you know what? I'm not even going to ask it. You just answer. Military police are threatening to charge a sex worker who offers discounts to Canadian soldiers, and senior leaders are warning troops to stay away from the Kingston area woman. Isn't she the one charging the soldiers? Oh yeah, it's like, hello Lieutenant, just leave the money on the nightstand. Such efforts have backfired, and sex worker Christina Leah Gilchrist tells the newspaper she's been inundated with messages from military personnel interested in the services that she provides. The selling of sex in Canada is legal, but military police allege that she broke the law with the unlawful use of military uniforms, according to police documents. Okay. I had no idea hoeing was legal in Canada. Well, there you go. Make sure you wear a rubber. Yeah. Wrap it before you stick it. Upon the review of your website, I noticed that you were not only advertising your services wearing a military uniform, which is a controlled piece of clothing, but also displaying other parties engaged in sexual acts while in uniform, military police stated in a message sent to Gilchrist on December 18. But Gilchrist, who offers discounts to Canadian Forces personnel, pointed out she repeatedly stated in her advertising that she is not or has never been a member of any military. What is she doing in the uniforms? It's a good question. I didn't actually want to go to the website because some things you just don't do for research, some things you do. Stolen valor. I've never walked around in public pretending to be a soldier, she explained. People in movies dress up as soldiers aren't impersonating soldiers, so why do military police that I think that I am? Military commanders at Canadian Forces Base Kingston also took the highly unusual step in mid-December of telling soldiers about the 32-year-old. Sweetheart, all I'm saying is that is the best piece of advertising you could have gotten. You have irritated the upper echelons of the Canadian military to the point where they have literally said to a bunch of horny men, stay away from this hooker. You cannot tell me that a bunch of blokes are not going to sit there and go, wonder why that is. Why do I need to stay away from her? You know, sometimes you just got to try something once, you know? It's like a donkey show or, you know, morbid curiosity. She's role-playing. She's not trying to get the Burger King discount. Exactly. Nothing more important than for Canadian MPs to do. It's awesome they got everything else taken care of. I know, right? It's not like they got shit to do. So there is a law for what you wear. There is in terms of military uniforms. Lots of guys standing to attention. They were deploying their field artillery. Make sure you wear your helmet. There's incoming! Love it. The internal message, noted that the escort in question has photos posted on their website as of yet unidentified clients in CAF uniforms in compromising positions. As of yet unidentified. They're actually looking into controlled clothing, so Canada doesn't have surplus shops. What I'm willing to bet is that it's the uniforms, but they've still got like ranks and insignias or like the flag or whatever else on it. Because I'm sorry, you can't stop someone from just wearing camo gear. That's you know. Stay away from her, boys. She'll S you D. Did she take the rear guard actions? Possibly. We will never know because I'm not looking at that website. The internal message provided has resulted in a booming business for Gilchrist. Traffic to her website skyrocketed to 10,000 views over a 3-day period. And she's receiving requests for her services now from soldiers across the country. They gave me all this free publicity, she said. After they made that memo, I literally had 10,000 hits on my website. What the did they think was going to happen? Yeah, there's a hot chick that's providing discounts to service military personnel. Don't engage with her. We repeat, do not engage. In a message to Gilchrist military police that they found her business cards at... she left calling cards. just... Break off, it's a trap. It could well be at this point. She might be a honeypot for all we know. They claim she'd committed 2 offences under the criminal code, one for advertising sexual services, contrary to Section 286 of the criminal code. Okay, now you know I gotta look that up. Section 286 of the Canadian criminal code. Hang on. It must be the military criminal code, in which case I'm probably not going to be able to get a hold of that because... Oh, no, never mind. The offence of obtaining sexual services for consideration. I thought it was legal. Section 286(1) of the Criminal Code is part of the new prostitution laws in Canada. It makes an offence to obtain for consideration or communicate with anyone for the purpose of obtaining for consideration the sexual services of a person. I thought it was legal. Now I'm confused. Hey, Aaron. She should have just said she was selling maple syrup. Ugh. Don't want up that maple syrup. The army can't crawl on its stomach with that particular appendage engorged. Americans don't have to go to Canada. Sex work is legal in the US, says all the Democrats. Tell that to Texas. Is her card in the bathroom labelled call for a good time, affordable rates? The trade is legal, pimping and advertising is not, probably. Okay. Provision criminalises the purchasing of sexual services but not the selling. I'm sorry, what? How is that allowed? You can't treat them differently on the opposite sides of the same transaction. It's legal if Trudeau approves. Provision criminalises the purchasing of sexual services but not the selling. It was enacted in 2014 in response to the Supreme Court of Canada's decision in Bedford to strike down a number of prostitution-related prohibitions. Subsection 1 creates a basic offence which may be prosecuted summarily or by indictment and which stipulated escalating minimum penalties for subsequent offenders. Subsection 2 creates an aggravated form of the same offence with a minimum sentence of imprisonment which is committed where the person provides sexual services under the age of 18. Oh. Mandatory minimum... Where the person providing the sexual services is under the age of 18, they put you in jail for a minimum of 6 months. 6 months for paying someone under the age of 18 to shine your knob. Decriminalised to sell, illegal to buy, protects those who would be victims of trafficking so they don't worry about being arrested for coming forward. It's the business card the same as the coupon. I don't want to know where she keeps the coupons, honestly, if I'm perfectly honest. Mandatory minimum jail sentence 6 months. It's not a defense that the accused believed the complainant was 18 years or older or more at the time of the offense unless the accused took all reasonable steps to ascertain the complainant's age. So basically, people, make sure you're carding your prostitutes, basically, is what that boils down to. The legal age to see in person is 16, but yeah. Look, as we know, laws are very rarely made to make sense. So, do I think I have a problem with legalized and regulated prostitution with stiff penalties for violations, no pun intended? Well, it works well here. We look after our hookers, okay? To the point where during the bug, we gave them health insurance through the government. Like, they received payments to make sure that, because they were out of work, they were still being looked after. Provided you're not selling it on the street, provided you're doing it through a registered brothel or you are yourself a registered agent or whatever else, it's a properly regulated industry. It fulfills a need. It fulfills a... there's a slot in society for it. No pun intended. Good thing it's not the Navy. They'd probably get crabs. And I'm always big on regulation over prohibition on anything. I'm fairly liberal in that sense, in that I prefer... Provided you're over the age of 18... and what you were doing does not cause harm or injury to anyone else, and everyone's consenting adults, you can do whatever you like. You can fuck up your own life as much as you like. I don't care. It has no impact on me. Nobody else should be clutching their pearls over it. You can go and do whatever the hell you want. Okay? Oh, and leave animals out of it as well, obviously. Like, well, actually, I kind of covered that when I said consenting adults. It does solve a lot of problems if they're properly implemented. Yeah. Hold on, socialist Canadian medicine doesn't cover prostitution? Apparently not. Is there a drop in rape cases? Yes. There is a measurable drop in crimes. So, some men need that access safely too. Exactly. And, like, bad as it sounds, especially with all, like, the red pill stuff going on now as well, with a whole bunch of people waking up and realizing, hey, maybe marriage isn't the best idea for men to rush into. I put it to you this way, people. Marriage now is not what it was 5, 10, 15, 20 years ago. Because now you've got very entitled individuals. Like I saw a video on Twitter yesterday. It was a black chick saying, oh, you know, if I'm dating someone, here's the things that the boyfriend needs to be covering. My rent, my electricity bill, my groceries, my insurance, my car payment, my everything else. And I'm just sitting there like, bitch, if you're dating... he can walk away at any moment. He has no requirement or responsibility for that. And she said, oh, all these things should be being paid in exchange for me having sex with him. Marriage is very high risk for the male. It is these days. It really is. MGTOW needs an outlet. That's one way of putting it, I suppose. Isn't that the definition of a hooker? So why not legalize it? That's what I'm saying. So, but anyway, shit, back to this. Sorry, I just had to look at that. Advertising sexual conduct, and the unlawful use of military uniforms contrary to Section 419A of the Criminal Code. I will look at that later because I want to know what constitutes a military uniform, because if she did buy something at just like the equivalent of Aussie disposals, it should not be counted as a military uniform. Further, as our investigation continues, if it is discovered that you received your uniform from another Canadian Services Force member, then an additional charge is present. What, receiving stolen goods? Married for 42 years next month. If it was today, I would not. That's what I'm saying. Actually, I talked to Mel about it yesterday, and I did the math. Well, we did the math, I should say. This year in October, we're 9 years, not 10. That's actually next year. I fucked up. I got the year wrong. Still remember the date, but got the year wrong. And we both looked at each other and we said we could not imagine being in the dating market now. Like, we could not imagine wanting to get married if we were to split up. It is just what it has been perverted into. Like, the destruction of the family unit, the destruction of just, like, care and loving, and, like, I doubt the skirt was GI. Yeah, well. If a girl wants a dude to pay her rent, she ought to be willing to sign a paper that says she's with him till death. More to the point, she should be willing to sign a piece of paper that says she won't take half his shit. I will say this, gents. One thing that I've seen and I can attest to, MGTOW does date, they just tend to be far more selective with no plans for serious relationship and consider a release while focusing more on themselves, following feminism tactics. If it's good for the goose, it's good for the gander. Actually, that does remind me of something else that I saw recently, which was a post by a woman who basically got upset because her boyfriend advised that he didn't want to get married because there was no benefit for him. He was more than happy to be in the relationship with her, that he loved her, he cared for her, and would look after her. But He made significantly more money than her. He owned significantly more assets than her. He worked a significantly more prestigious profession than her. And he didn't believe that it would change anything in their relationship. So he didn't see any point. And she broke up with him. And she posted that as a, get a prenup or a postnup. Depending on the state, depending on the country, the prenup or the postnup may not be worth paper that it's written on. Just be careful. But, you know, I don't give legal advice. We know this. No fault divorce is awful. My mum walked out after 30 years for no reason. It sucks. The whole point of marriage is you both become one, so make sure before. Exactly. I use old US Marine Corps utility uniforms given by my brother for hunting. I refuse to claim I served, just good enough to fool hogs, ducks, and deer. Cool. Stolen valor equals illegal. Using surplus to hunt fine in the US. Yeah. But Gilchrist points out that advertising for sex is legal in Canada. It is perfectly legal for me to advertise for myself and for me to sell my own services as long as I'm the only one profiting. That isn't really what the criminal code said, but okay, I'll listen to you on that. Prostitution involving individuals wearing military uniforms is rare in Canada. And those that have gone forward have focused on individuals who have been specifically masquerading as Canadian soldiers. In 2015, a man from Cantley in Quebec pled guilty to 2 counts of unlawfully wearing a military uniform and medals. He was spared jail and given a suspended sentence, 1 year probation, and ordered to do 50 hours of community service. Another imposter was arrested by military police in November of 2011, but not before the Winnipeg man attended several Canadian Forces functions and was profiled in the local newspaper in full military uniform as a soldier headed to the Afghan war. Whoops! Stolen valor isn't illegal though. Well, they're saying that it is. At this point, marriage is a legal process that complicates things. It certainly can seem like it. Be good with a commitment ceremony, nothing legal has to take place. There is that. There is that. The one time that I had Joe sort of stop and think about something was when I was talking to him about how marriage, as bad as it sounds, is no longer necessarily religious, but that at the same time, it should not necessarily involve the legal implications of the aspects of it as well, because there's a social construct around it now as well. Because I'm not particularly religious, but I always knew growing up from a young age that I was going to have a wedding, that I was going to marry my wife, that I was going to enjoy that day. It is now a social construct as well as a religious ceremony, as well as a legal thing that the state has inserted themselves into as well. As far as I'm concerned, the state can get... What I do in my relationship is no one else's business. They don't think stolen valor is illegal in the US. Obviously, some stipulations apply. Yeah. Better privates are first class. But yeah, because it's literally, okay, fine. My little girl, as it is already saying, because she saw photos of her mother in a wedding dress, and she's like, Mommy, I want to look as beautiful as you do on my wedding day. Like... Aussie being like a little girl dreaming about his wedding day growing up. Oh, bite me. Look at it this way. From the age of 13, I knew I was a dad, mainly because I was the dad of the friendship group and everyone acted that way, and I was just the one taking care of everybody. Signing the marriage document, just saying no, that's lawfully committing. Okay. What's that? Tell that to all the people who get busted for stolen valor, nothing happens to them. I was even told while in the military that nothing happens. Military has no bearing on day-to-day. Police, on the other hand. Yeah, well. Alright. Although he was facing a maximum sentence of 6 months in jail, lawyers recommended that he be spared a criminal record. The judge agreed and the young man was given a discharge because his motives were not deemed malicious. Gilchrist's website has multiple disclaimers emphasizing she has never been a member of the military. Canadian military uniforms and medals are readily available from sellers online and surplus stores throughout the country. There you go. There it is. The store purchases the uniforms from the federal government as part of a surplus package. In addition, there are commercially produced copies of Canadian military camouflage pants and jackets. Gilchrist has been a sex worker for around 10 years. I'm a sex worker and I was a sex worker long before I became interested in the military, she explained. I developed a military fetish while living in Kingston and now I really like them. She likes the men in uniform. How I would love to see more legislative incentives for marriage and children similar to Hungary to push native population replacement instead of population replacement. Yeah, but they won't want to do that because the great replacement is happening across all Western nations. We know that. Detect high spots on bearings, gears, and other close fits. Alright, where are we? Prefer them to be in their uniforms because I am actively a military fetishist, she said. I love them in the uniform. So f them in their uniform. Be my guest. Clearly it gets you off. Clearly it would mean that that explains the discount. That actually explains the discount. But the point is, don't post those particular photos on your website. It's really that straightforward and simple. National Defence spokesperson Frederica Dupois said military police and Canadian Forces National Investigation Service were investigating after explicit advertising was found in military accommodations. Phrasing. No, I said exactly what I wanted to. With you, Hayden, I knew I was going to be a father and a husband when I was young too. Don't listen to the betas. Beta! In the Jesse Lee Pearson voice. Did the same thing with Sheeb. Yeah, I'm still hopeful. I am still hopeful. I'm not counting on it, but I'm still hopeful.
This shit, I'm out. Fuck this shit, I'm out. No thanks. Don't mind me. I'ma just grab my stuff and leave. Excuse me, please. Fuck this shit, I'm out. Nope. Fuck this shit, I'm out. Alright then. I don't know what the fuck just happened, but I don't really care. I'ma get the fuck up out of here. Fuck this shit, I'm out.